your host, Gary Austin.
Hi, this is attorney Gary Austin. One of the questions I get repeatedly from clients and prospective clients and the public is, how do I get full custody of my child? Totally understandable question. Let me share with you my experience. Typically in the state of California, the standard is joint legal and joint physical custody. So the state decides, hey, both parents are going to have some custody. So in answering the question of how do I get full custody, there are some things I have to share. One is, if you're getting full custody, typically it means there's something going on of a nature that's going to require the court to step in and protect the child. By protect, it does not mean simply that one parent says, I don't like something with the other parent, our relationship is going poorly, or I disagree. Protection typically means that you, as a parent, can provide or give some information to the court that indicates that the child is in harm, jeopardy, or facing something significant relative to the other parent. Here are some examples. One of the easy examples is possibly smoking in the child's presence, where the child is subjected to secondhand smoke. Something else, maybe a parent who drives under the influence with the child in the car and is subjecting the child to child endangerment. And one of the more obvious and common ones is if the child is being abused or subject to some form of domestic abuse, where you have to go and seek out a domestic violence restraining order, an emergency protective order, or possibly bringing in law enforcement or a third party to protect the child. But in those cases, you are bringing in additional sets of eyes, whether it be court, law enforcement, child protective services, or someone else, or independent evidence that's going to show that the child needs to be protected. So again, when I hear the question, I want to get full custody, it's not impossible. It is quite possible, but the circumstances have to be right. Now, if you want to talk about your particular case and you need some assistance, legal assistance in family law matters related to custody or divorce or other areas of family law, please reach out my office and let's see if we can work together. Another question that I routinely get, and this is a more specific question, is, after I've lost custody, how can I retain or regain joint custody of my children? Well, it is possible, and it happens every day in family law courts. But usually you, the parent who has lost custody, is going to have to demonstrate or show or prove to the court that you've taken certain necessary steps in order for the court to be comfortable with you having joint custody of your child. Joint custody is typically you're involved in the decision-making process with the other parent, whether it be going to school, activities, or things like that, as well as joint physical custody, meaning the child is with you for significant periods of time. Now, how do we get there? Usually these situations arise when there's been a restraining order, for example, and when a restraining order is granted, the other parent gets sole legal and sometimes sole physical custody or both. You usually are going to have to take a class. For example, one of the requirements out of a restraining order is that a domestic violence prevention class be taken. It can be up to 52 weeks, or depending on a case or the severity of the case, the judge can reduce it. There also may be a requirement that you take a parenting class to show to the satisfaction of the judge or court that, in fact, you are now capable of engaging in parental activities when in the past, for some reason, again, could be domestic violence, abandonment, or some other situation, they felt the court believed it was better to protect the child from you. Also, if there's drugs or alcohol involved, you may have to take a course there. More important, or as important, is you being able to communicate effectively, clearly with the other parent when it comes to things like visitations, whether they be supervised or not. When there's a restraining order, oftentimes there is a supervision requirement, and that supervisor is going to make a report to the court. What you're trying to demonstrate to the court while you try to retain and regain joint custody is that you are on your best behavior, that there is no need to be fearful of your actions towards your child, and that you want to be in your child's life as much as possible. Now, if you want to talk to our office about situations that you may be in and work with someone to help you regain joint custody of your child, please reach out. Answering another question I routinely get is, do I have to let the other parent see our child or children if they're not paying support? The answer, possibly counterintuitively, is yes, you do. In California, the courts and judges typically don't like to horse trade when it comes to children relative to the two big issues they have. One is support and the other is custody. Because what it would likely do in the court's mind, and I concur with them on this, is it would slow the system to a halt if all battles were on, did you pay child support last month? There are other ways or remedies to go about that, one of them being contempt. But typically the court does not allow what I'll call tit for tat, quid pro quo, when it comes to the children and custody and child support. So if that is the case, you are still going to have to allow the other parent to see the child, even in the event that they're not paying child support or paying less than they're ordered to do. Now, the flip side of that is a judge is likely not going to modify custody orders in the event someone blatantly refuses to pay child support. So the judges are sensitive to the issue. They're aware of it. It happens oftentimes, but they're not going to reward someone for bad behavior. So you can keep in mind that a judge will likely say, why would I change the order and give you additional or increased time unless, maybe they can show it, unless it's in the child's best interest. But that's going to be coming from someone who lacks credibility. So my standard answer is, yes, you still have to follow the order, but I don't think the court is going to offer or give the non-paying parent greater leeway and encourage non-payment when it comes to custody. If you have a situation of something like this and you want to work with someone who can help you address these issues, please reach out to our office.